Boy, that really hits you there, doesn't it? Wow, what a great story. All right, let's talk about this Occupy Wall Street story. It started out as a simple disorderly conduct case. Then all of a sudden it turned into a major legal fight over privacy and Twitter. An Occupy Wall Street protester was arrested in October of last year. Remember this? He was marching on the Brooklyn Bridge along with a whole bunch of others, and now the Manhattan District Attorney wants access to the defendant's tweets to show that he and other protesters knew that occupying that bridge was illegal, which would contradict his claims that demonstrators thought they had permission to be on the bridge. Joining us now are former prosecutor Doug Burns, defense attorney David Schwartz. So, David, if the guy goes out onto this social network public forum and makes a statement that shows he's lying to police, there's no expectation of privacy out there.
Right. I don't even think Doug Burns could argue an expectation of privacy as good as you are, Doug.
Thank you.
But no, there obviously, you know, when you use Twitter, you're tweeting out in the public domain. There is no expectation of privacy. And, of course, the information is material to the DA's case. So they have every right to subpoena. I don't expect them to be able to quash the subpoena.
Because it arguably shows he gave false statements to police.
Well, there's three separate categories. First of all, it's a statement of the defendant, which is discoverable. Second of all, he has no expectation of privacy because, to keep it simple, if you tweet something to the world, it ain't private.
It's like standing in a park with 20 people and yelling something.
Right. And third, just quickly, guys, is the fact that unless it's legally privileged, by the way, right?
But that would have to be priest, penitence, privilege,
and
doctor, patient,
and there's
lawyer,
no privilege.
client.
Right, exactly.
All right. All right, we've dispensed of that.
Yes, that was easy.
That was the easy one. This is the tougher one. Let's turn to this legal case. George Zimmerman is suing NBC, the television network, alleging that the network defamed him when it edited the recording of his 911 call to police about the death of Trayvon Martin. Zimmerman's attorneys accuse the network of intentionally making Zimmerman sound like a racist. Now, here is the edited version.
This guy looks like he's up to no good. He looks black.
All right, sounds like he's volunteering the issue of race there. Well, listen to the unedited, real conversation.
This guy looks like he's up to no good, or he's on drugs or something. It's raining, and he's just walking around looking about.
Okay, and this guy, is he white, black, or Hispanic?
He looks black.
Well, joining us once again, Doug Burns, David Schwartz. All right, look, David, let me start with you. And let's put up on the screen NBC's statement about this lawsuit. What they're essentially saying is that it was an honest mistake. It wasn't intentional, just kind of a dumb error made by somebody trying to shorten up a soundbite. Although it ended up being wrong, untrue, and inflammatory, and it ginned up racism. So can Zimmerman win?
I don't think he could win in this case. There's a lot of obstacles to go through, Greg. Number one, you have to prove that the statement is false. The statement is not per se false. They take two different parts of a statement, leave out the entire middle, but is the statement false? That needs to be litigated. I'm not so sure Zimmerman could prove that.
That's also a distinction without a difference, isn't
also,
it?
can Zimmerman show that there was malice here? This is a public case. He's a public figure at the moment, and they have to show actual malice, not just plain negligence, and that'll be a tough one to
Doug,
hurdle.
there's another kind of defamation here that applies.
There is. It's called false light defamation. And while I agree with David that you don't have a traditional cause of action, i.e. the statement is false, you do have potentially portraying him in a false light, which is that he racially did it. Also, I'd add into the mix, Greg, that two of the people were fired from NBC. I'm not sure whether that's admissible. But it could be.
Look, they're admitting that they made a mistake. Their argument is the mistake was unintentional. But look, it's always hard to prove a defamation case, especially when you have a public figure. Now, this guy on the witness stand right there, George Zimmerman, who's the plaintiff in this defamation case, he has to prove actual malice, because he's actually an involuntary public figure, right?
Yeah, absolutely. He's got to prove actual malice, which is much different than ordinary negligence. So was there an intentional act here with malicious intent? And I'm not so sure they could prove that on the part of NBC. You know, the false light, as Doug brings up, is a good point, but still, the statement itself is a truthful statement.
You'd have to get somebody at NBC to say, we knew that this was false, and we decided to put it up there.
Or other evidence.
All right. Now, interestingly, Doug, there's a Florida statute. It's called the retraction statute, and it basically says that if you take it back right away, and if you air the correction or retraction in a comparable broadcast, then all you get is a little actual damages, no punitive damages, and so forth. But NBC didn't do that.
No, it's kind of amazing. We have that all across the law. For example, even in perjury, you can come right in, you call the prosecutor, he wants to come back in Monday, clear up what he said, and I've seen those retractions. So here, NBC's being stubborn, but there's a little surprise here for Mr. Zimmerman, bad news, and that is that if you listen to the entire tape, there's another separate racial epithet, okay?
But I'm not sure that's admissible. First of all, the audio is unclear.
Right, I listened to it a couple times. It's sort of like song lyrics. When you know the lyric, you hear the words. And I think he may have said an epithet in there.
It's certainly admissible towards the case. That'll certainly be admissible. But you know,
NBC did not apologize directly to Zimmerman. And then they make a correction that's on a piece of paper, not on the Today Show broadcast.
Well, look, they made the correction. I don't think Zimmerman has a case, and I think there may be another angle here for Zimmerman. There is the court of public opinion in this case, which has gone terribly against him. He may be using this case to gain favor in the court of public opinion, and it may be a good strategy.
I don't know what the deal is with some journalists and media companies. You make a mistake, you immediately apologize, and you do it in the same big way that you made the mistake.
Absolutely, we agree on that.
No question.
They didn't do it.
I agree.
David Schwartz, Doug Burns, good to see you both.
Thank you.
All right, Heather?
Coming up, a setback for organized labor after Michigan passes new right-to-work laws. Now unions are gearing up for massive protest. Are they right to be upset? A fair and balanced debate up next.